Christy and Michelle, is there going to be an introduction, or did you want me to start?
You can go ahead and get started.
Okay. All right. Good morning, everyone. My name is Matt Scully. I'm a partner in the Labor Employment Group for Burr Forman. I'm in our Birmingham office. Today, we are going to be talking about the Pregnant Worker Fairness Act. It's an exciting day because it's not often we get to talk about a new law in the employment space. This law, as a name indicates, is protections afforded to pregnant workers. This is an area, it's a somewhat crowded area of the law. There's a number of laws that exist that protect pregnant employees. And so what we're going to do today is we're going to talk about those laws, what they mean and how they work in this new law, and what gap it fills and how they all work together. I hope you find this helpful. It's not going to be a long presentation. The law itself is not long. It's not particularly complicated. We don't have any guidance right now from the ESC about how it works. You'll see from the language in the law, the PWFA is what I'm going to refer to it as, the Pregnant Workers Fairness Act. It uses language that's very similar to that from the Americans with Disabilities Act. So many of you will probably be familiar with the language and how it works. But while I'm presenting, please feel free to ask any questions. I know there's a comment section. I think it'll be helpful to ask questions. I may not be able to answer them, probably not. But I think if you're thinking it, others might be. And there's a bit of uncertainty about this law right now, particularly without guidance from the ESC. And I think it's helpful to think through issues collectively as we're all trying to figure it out. Okay. So what is PWFA? So in December 29th, 2022, as part of the Consolidated Appropriations Act, this law, the PWFA, was signed and went into effect. It goes into effect on June 27th, 2023. So about a couple months from now, the EEOC will start accepting charges under the PWFA on that date, June 27th. So for events that occurred now and until June 27th, they would not be covered under the PWFA. They'd be covered under the other laws we're going to talk about, but until that June 27th date, this law is not going to be in effect. Fortunately, the EEOC has been assigned to issue regulations that will help all of us understand the PWFA and how that works. They have not issued those regulations yet, so we're currently waiting on those. All right, let's talk about generally what laws are out there, because I think it's helpful to understand what laws are out there to fully understand what the PWFA does. As a starting point, there's Title VII, and I think most of you are familiar with Title VII. Under the Title VII umbrella, there's something called the Pregnancy Discrimination Act. And so what the Pregnancy Discrimination Act, it forbids that discrimination against pregnant employees. So that could be hiring, firing, promotion, any sort of adverse action like that. You can't treat a pregnant employee differently based on their pregnancy. It does have an accommodation component to it. Some of you may recall in 2015, there was a Supreme Court decision, Young versus UPS. And in that case, the Supreme Court said, if a pregnant employee makes an accommodation request, if the employer gives those type accommodations to other similarly situated workers, it must provide it to the pregnant employee. The idea being, you can't discriminate against a pregnant employee. And if you've given this accommodation to these other employees who are similarly situated, denying it to a pregnant employee would be pregnancy discrimination. There's a lot of discussion at the time what this would mean and what would be the consequences of it. And some persons thought this would effectively mean pregnant employees would always be entitled to accommodations, because you could always find someone who had a similar situation, whether it be workers' comp or the Americans with Disabilities Act, and you gave that person an accommodation, so you'd have to give it to the pregnant worker. The reality is that can happen, but courts for the most part have limited its applicability, and it's frankly hard to find a similarly situated comparator. If you're a pregnant employee and you want to come in late due to morning sickness, especially for small employers, there may not be a person who needed to come in late because they had an illness. There may not be a workers' comp situation on point, and the courts, the way they were analyzing is just finding a workers' comp comparator, someone providing light duty as part of a legal requirement or for a legal benefit isn't always going to be a similar situated comparator. So, starting out, you got Title VII, it prohibits pregnancy discrimination, touches upon some accommodation issues, but it doesn't really go that far. Your next law is the Americans with Disabilities Act. So as most of you know, disability is a physical or mental impairment that substantially limits one or more major life activities. And so someone disabled, you can't discriminate against someone who's disabled, and you have to provide them a reasonable accommodation. Pregnancy is not a disability. Complications from pregnancy can be a disability. So if someone has, for example, gestational diabetes or preeclampsia, those could, under certain circumstances, be disabilities that would require an accommodation. An accommodation is something that's reasonable and that doesn't cause an undue burden. So within that ADA umbrella, you would have pregnancy issues come up, but it wasn't just, I'm pregnant, I have morning sickness or I have fatigue. It would come up where I have a medical condition because of my pregnancy. I need an accommodation. And under the ADA, there are protections. An employer doesn't have to eliminate essential job functions. The employee is entitled to accommodation, but it has to be reasonable and it can't create an undue burden. So you would see some ADA pregnancy accommodation claims come up, but not a lot. And there's always that issue of are these short-term conditions? If you have a pregnancy condition, you're about to have birth in a month. If I just have a medical condition for a month, is that really a disability? And there's a lot of courts that indicate a condition that lasts a month wouldn't be a disability under the ADA. So there's a lot of legal gray area on this, and we'd see some claims under this part of the ADA for pregnancy accommodation discrimination, but it wasn't, for pregnant employees, it didn't provide them a lot of protection. It provided some, but not a lot. The next law is the FMLA. So FMLA, so the first two laws, Title VII ADA, applies to employers with 15 or more employees. The FMLA applies to employers with 50 or more employees in the 75-mile radius. And to be an employee eligible to use FMLA, there's certain obligations in terms of duration of employment, 12 months or more, and then 1,250 hours in the last 12 months. So the FMLA doesn't apply to all employers, and it doesn't apply to all employees. Under the FMLA, employees could take 12 weeks off for the birth of a child. This is called bonding leave. So if a child's born, the opportunity is there for 12 weeks off to bond with the child. FMLA could be used for prenatal care, for example, doctor's visits during the duration of the pregnancy. That was something FMLA an employee could use FMLA for. And then incapacity related to pregnancy. So if an employee, for example, morning sickness or bed rest, those could be areas where the FMLA would entitle an employee to time off. And of course, if an employee had a serious health condition due to pregnancy or following the birth of a child, that would be covered. FMLA is not an accommodation law. It's a law that would entitle employees to time off. So I think that's an important point. And then the second point is, the FMLA, there's a process. And from the employer's perspective, that can sometimes create headaches, but there was documentations, there was medical records you could receive, there were doctor's notes you could receive, there were temporal limitations, there were clear rules to follow. So the FMLA would provide a lot of protections to employees, but generally it says larger employers, it's employees with some duration for the employer. And this is not, the FMLA is not designed, well, I need 10 minutes a day for a water break because or to sit down due to my pregnancy. The FMLA would fall into the category of time off for these conditions, whether that's prenatal care or incapacity related to pregnancy. So you've got those laws protecting pregnant employees. The Pump Act. So this is a new law that's going in that just went into effect. In fact, the full import law went into effect today. The Pump Act, many of you may recall, and this was in 2010, there was an expansion of the Fair Labor Standards Act that provided non-exempt employees reasonable break time at a private location other than a bathroom to express milk 1 year following the birth of a child. So what this Pump Act does is it expands those protections to all employees, exempt and non-exempt. It also provides for enhanced remedies. So previously, it wasn't really clear what remedies would be available if there was a violation of the law, about expressing breast milk. Now it's clear the remedies under the FLSA would be available. So the Pump Act is something you'll need to be thinking about. It's kind of part of this alphabet soup of laws that we're dealing with. The one part of this that I think is helpful is before an employee can commence an action against an employer for denying them that right, the affected employee must notify the employer of the need to express milk and the failure to provide an area. So if you're a small business and you're not going to, lawsuit's not going to show up one day where it says you didn't allow me to, there's no dedicated space for me to express breast milk. The process is that an employee will have to come to you first. When that employee comes to you, then you can discuss with the employee where this is going to happen, how it's going to happen, reasonable time to do it, and all the, engage in that process with them. So I think that there's some help to this, that there's going to be a, more or less a notice requirement that you need to do this. I still do recommend that employers have a provision in their handbook discussing this right of employees to express breast milk, and making clear if this is something you want to do, come to us and we'll work with you to get you a place. So if that's not in your handbook, it's something I would recommend putting it in your handbook. And on top of that, some employers provide leave off for employees for pregnancy. Short-term disability can cover some disability or time off related to pregnancy. So there's a lot of laws in place that protected pregnant workers. But what was missing, if you haven't gathered it, is this accommodation part. There's accommodation part if you have a disability. There's an accommodation part where you can't be treated worse than other people. If you've let non-pregnant employees do this thing, come in late to work when they're sick, you can't discriminate against a pregnant employee simply because they make that same request. But there was a gap for the employees who may not have a serious medical condition, but due to pregnancy complications need accommodation, whether that's coming in late, whether that's a schedule break, whether that's being able to sit down and take breaks from work. There's really not a good law that those pregnant employees could look to ensure them that they had a right to do that. And so that is where this new law comes in, the PWFA. Okay, so the PWFA, so it applies to private and public sector employers with at least 15 employees. So if you're under 15 employees, good news, this law doesn't apply to you. You can, of course, comply with it and give employees these rights, but you're not under a legal requirement to do so. What it says is it requires covered employers to provide a reasonable accommodation. So reasonable accommodation, that probably sounds familiar to anyone who's dealt with the Americans with Disabilities Act. And the idea is similar. I would call this reasonable accommodation plus, because it's a little more than what's under the ADA, but that's a good starting point to think about this issue and how things work. The next slide, we'll go over some examples the EEOC has given us of accommodations, but generally an accommodation is going to be a modification or adjustment to a job or the work environment that enables an employee an equal opportunity to successfully perform a job. So if an employee wants a modification or adjustment, those could be reasonable accommodation requests. And an important part of the PWFA is going to be the interactive process. It seems from what we can tell is that that's effectively going to be a mandate. If an employee comes to you with an accommodation request, you have to have that interactive process. And that's similar to the Americans with Disabilities Act. So you're probably familiar with that. But here, I think it's going to be critical to start that dialogue because there's some nuances about how that works. And so when you have that interactive process, you'll talk about things like job restructuring, part-time or modified work schedules, any equipment that could help them do the job, changing tests, training materials or policies. So that's going to be something that probably an obligation you didn't have before. If the pregnant employee came to you and had these concerns, you may have felt you didn't have an obligation to do these things. Some employers did, but the PWFA is going to put an obligation on employers now. Now, one thing that's different from the ADA, anyone who's dealt with ADA or litigated it, an employer generally is not supposed to eliminate essential job functions. That's kind of a hallmark of the ADA. You know, there are some basic requirements of this job, the essential job functions, and it's not an accommodation to request that we eliminate those. You know, if your job is driving a forklift, essential job function would be the ability to drive. And if an employee can't drive due to a medical condition, you would not have to eliminate that job function, which makes sense. Under the PWFA, that from what we can tell is not a defense. So you may have to eliminate essential job functions. So you may say, well, attendance is an essential job function. We have a demanding customers and you have to start at a certain time period because our production cycle needs people to start at 8 o'clock every morning, for example. An employee who requests an accommodation adjustment for the last month of her pregnancy, for example, wants to come in late because of morning sickness, a defense is not going to be, well, timely attendance is an essential job function. We can't eliminate that for you. So I think that's going to be an important thing to think about as you're working through these PWFA issues is we don't have that defense. Well, this is essential. This is critical to our job that you would have under the ADA. What is not clear to me, and I certainly hope will be the case because it is under the ADA, is that employers requesting an accommodation have to provide a doctor's note. You don't have to require a doctor's note, but you can. So if I'm a disabled employee under the ADA and I want a medical accommodation, and employers are well within their rights to say, unless it's an open and obvious need, that we want a doctor's note supporting your condition and your need for an accommodation. I hope that this is going to be a similar right employers have under this law, whereas an employee says, I have morning sickness and therefore, I need to come in late every day. An employer could say, well, can we get a note? We'd like a note from your treating physician saying this, and we'll engage with you and work to accommodate with you. If that's not the case, I can certainly see a lot of potential for abuse where any employee could simply say, I want this, I want that. And if employers don't have the opportunity to get a doctor to confirm that this is actual need the employee has based on the pregnancy, it could be an opportunity for abuse. So I think that's something to watch closely, especially when we get the regulation guidance from the EEOC about how this works. But if you had to sum up what I said, what I just talked about, the reasonable accommodations, if a pregnant employee asks for an accommodation, it's likely going to be reasonable and it's likely something you're going to have to give to them. So I think I would prepare internally, management, policies, training. When these accommodations come through, odds are we're going to have to comply with them. It does provide, if you look to the bottom of that top part, it references undue hardship. So the undue hardship, it's going to be the same standard as it is under the Americans with Disabilities Act. Undue hardship means a significant difficulty or expense. And what it does is it focuses on the resources and circumstances of the employer and the cost of providing that accommodation. Example under the Americans with Disabilities Act would be, I need new equipment that costs $15,000 to do my job. And if you're a small employer, you could say this is cost prohibitive. This is a position where we pay the employee $30,000 a year. we have, these financial limitations that would be cost prohibitive. It doesn't come up a lot, especially for big employers. And it's rarely successful when the argument's made. Here under the PWFA, I think it's even more likely it's not going to be effective because these accommodations are going to be short term. If a pregnant employee needs 1 month, 2 months, 3 months of this, adjusted schedules, additional equipment, taking breaks for 15 minutes, it's going to be very hard to describe why that imposes an undue hardship on you, especially for big employers. So I wouldn't take a lot of comfort in, well, it can impose an undue hardship on us because that's usually going to be a losing argument. This applies to applicants as well as employees, and I think that's an important note to make. That would be applicable under Title VII of the Pregnancy Discrimination Act, but all the rights here apply to applicants. So if I'm an applicant for work, and as part of that application process, a person says, well, I'm pregnant and I can't stay on my feet for more than an hour or two. So the first couple months, I'll need an accommodation in terms of how long I stay on my feet. That would be, square within the PWFA, applicant requesting an accommodation, and likely something you would have to consider and give to that person if you end up hiring them. Doesn't mean you have to hire them, obviously, if they're not qualified and otherwise don't meet the criteria you need, but that certainly can't be a reason why you wouldn't hire someone. And, as anyone who's been involved in litigation, when there's close timing, someone asks for an accommodation and you end up not hiring them, for example, there's always going to be a suspicion that did you have a bad motive and what really motivated your decision. So I think it will create another level of complexity to hiring decisions for employees who do make these type requests. So it covers the worker's known limitations related to pregnancy, childbirth, or related medical conditions. So and keep in mind the known limitations. So these are what I would call medical limitations caused by, pregnancy, and that could be morning sickness, that could be, fatigue quicker. Those would be symptoms and the related medical conditions of that, and childbirth. And where I think this will get interesting is limitations related to childbirth could be time off. So I've had a child. I need 6 weeks off as part of this because of whether it's PTSD, some emotional issues after having a child or whatever they're going through. I think this can come up a lot with after childbirth, where an employee wants a little more time off or time off, period. And that's something, if you weren't covered under the FMLA, you probably would have had a right to say, you had had a legal right to say get back to work. Some employers would have maybe said, here's some time, we'll give you a week, 2 weeks, or you can use your paid time off. But now there's a law on this issue, and it has to be a reasonable accommodation. So, under the ADA, Americans with Disabilities Act, a reasonable accommodation can be time off for 3 months or longer. And so we don't know exactly how that's going to apply here, but I would be prepared for extended requests for leave, and it's complicated in how those are going to be handled and how much time a person would be entitled to. So, that is the PWFA. We're going to talk about some guidance we've received from the ESC, but, I think a real simple way to think about it is it's almost Americans with Disabilities Act plus. If you have a framework and you understand the ADA, this is it, but more, but less legal rights, probably a higher obligation to provide accommodations, and more accommodations that would be appropriate for employees. And if you get an accommodation request, you're likely going to have to comply with it. And I think that's just how to approach these issues. There will be situations where you won't, but those are not going to be the common. And I would certainly think you should consult legal counsel before you would deny any accommodation request. The good news is I think a lot of employers already work with employees on these issues. We don't see a ton of pregnancy discrimination claims, even with all these laws I just discussed, because I think this is an area where employers generally are sensitive to people and work with them. But this will create another level of complexity. The EEOC, so they have, and you can find this online, they have issued some preliminary, a memo about examples of possible accommodations. And these are the examples given. And I think it's helpful to kind of put some context of what are the type of accommodations that the employer may have to give. And so the employee may need to sit or drink water. And, that could be sit. I need to sit down for 15 minutes. I need a break to sit for 15 minutes. It could be I need to sit to do my job. And, if the ability to sit, if they can't do their job and sit, then you can get into complications. And I think that's where you have the interactive process. How long do you need to sit? Well, I just need to rest my legs for a time period. Okay, well, let's take a break and then we'll get you back to work. That's going to be this back and forth. But what you can't do is just say no right off the bat. Receive closer parking. So this would be an employee who has trouble making a long walk. Again, I hope we can ask for a doctor's note where, the doctor says, due to the pregnancy, I think it would be helpful for the pregnancy that an employee needs to be closer to the facility. Again, you could see where this could be abused. A lot, certainly is necessary in some situations and has a lot of benefits, but I think there's a risk that employees could take advantage of this. Flexible hours, coming in late, leaving early, time off for doctor's visits, all those things are going to be accommodations. Appropriate size uniforms and safety apparel. So if the uniforms don't fit or the safety equipments don't fit, that's a reasonable accommodation to give that employee new uniforms and safety apparel that fits. We talked about the break time, bathroom, eat and rest, and then leave time off to recover from childbirth. So we talked about that earlier. Those employers who haven't been dealing with FMLA, this could be very new to them. An employee requesting time off to recover from childbirth. How long's reasonable? If a doctor says 3 months is reasonable, who are we, the employer, to say that's not the case? So I think that's something that we're going to see a lot of and need to be prepared for. And being excused from strenuous activities. And that involves exposure to compounds not safe for a pregnancy. But I think that could be expanded upon to strenuous activities that aren't good for the mother, expecting mother. With many of you probably received accommodation requests from doctors where a pregnant employee says she can't lift. And that would be a strenuous activity. That would be an accommodation request. And you'd want the employer to deal with, you'd want to deal with that as any other accommodation request. And this is the last slide, and this is also pulled from the EEOC guidance, and it's some bullet points of what the law prohibits. Requiring an employee to accept an accommodation without a discussion about the accommodation. So this is something that, and I think you can tie that into that third part too, requiring an employee to take leave. Another reasonable accommodation can be provided. So under the Americans with Disabilities Act and the 11th Circuit, we've talked about the employer reasonable accommodation obligation, but the accommodation only has to be reasonable, and you don't have to give what the employee wants. So if an employee wants A, B, C, and you, the employer, think C is a good outcome and you're agreeable to it, you can give C. If an employee wants A, employer comes up with B, and the B option is reasonable and allows the employee to perform the essential job functions, you can go with B. PWFA doesn't seem to work that way. An employer can't say, oh, you can't work, you want these adjusted work hours, you want to take a break every hour for 15 minutes, we're just going to give you unpaid time off. You just take off 2 months and come back when you're ready. The PWFA prohibits that. And so I think that's going to be something new to employers is rather than the employer dictating what the employee gets, obviously it has to be reasonable and solve the issue. The employee is going to have more control over this process. And so if an employee proposes an accommodation to you, you can't say, well, you do this option instead of that option. Here, there's going to have to be a discussion. And if the issue is leave, You can't force them to take leave as an alternative to working. So that's going to be, one of the most important takeaways from this, I think, from employers, because that's where, in my mind, one of the big differences from the Americans with Disabilities Act. I think most people are just going to think this is ADA. I know reasonable accommodation. I know interactive process, but this is a little shift in how that works. That second bullet point, denying a job or other employment opportunity to a qualified employer applicant. So this could be, denying them, firing them, discharging them, demoting them, not promoting them because they're pregnant, based on their need. What is not clear to me is this going to be based on if they ask for an accommodation? Could it be based on a perceived need for an accommodation? Kind of where's the line on that? But, the important point is to remember pregnant employees are in a protected class. You don't want to take their pregnancy into consideration in anything you do, hiring, firing, promoting, any sort of adverse actions or positive actions you would take. You don't want to consider pregnancy in that decision-making process. There's a retaliation component. You cannot retaliate against an individual for reporting or opposing unlawful discrimination under this law or participating in investigation. So this works like, I think it's going to work like any other retaliation component we have in our employment laws. Someone asks for a right, someone complains they're denied a right, you can't retaliate against them. If someone participates and puts you on notice of a potential work violation, you can't retaliate against them. If someone puts you on notice of these potential legal violations, you want to investigate, just like you would a complaint of harassment or a complaint of discrimination. You want to do all the steps you would normally take. You want to have policies that prohibit retaliation. Speaking of policies, I think, one to do from this is update your policies on the PWFA. Most of the employers handbooks I've been doing now, and I see have parts about ADA accommodation. If you need an accommodation, here's who you report it to, here's what we'll do. And that's helpful as a defense in a lawsuit. I would recommend including these PWFA provisions now in handbook. If you're pregnant, here's what you do, here's what you ask, we'll work with you, reasonable accommodation. I think that's going to be an important step, important to showing good faith, important in defending a lawsuit. If an employee says, well, I didn't know, they didn't seem to like pregnant employees and I didn't want to ask and I was afraid to ask and there was no policy saying I could get an accommodation. And so when I couldn't do the work and I got fired, it was unfair to me. I think it's helpful to say, no, we had a handbook. We encourage you to go to a supervisor and ask questions and we would have accommodated you. So that's, a to-do from this, I think, is to get your handbooks. And this law goes into effect in June. So, whether, you do this at the end of the year when you update your handbooks, I don't think it's an end of the world situation if you wait until November, December, when you normally update your handbook to do this, particularly those who have, a long process for updating handbooks. But if you have an easier process or quicker process, and I would recommend you do it before the law goes into effect. But that's something, you can talk about with whoever your counsel is, or work with me or anyone else at our firm. That last point, interfering with an individual rights under PWFA, that's not really clear. What is interfering? It could be a lot of things. Obviously, denying a request for an accommodation would be interfering. How broad it goes after that is not really clear. But these concepts should generally not be foreign to anyone who's dealt with employment laws. Can't discriminate, can't retaliate, engage in the interactive process, reasonable, accommodate people. So there is a lot of overlap. And I think that helps because there's a framework. We can all analyze these requests, but there's some nuances to this law that maybe, we hadn't dealt with before. So I think it's important to just keep that in mind. Both you, HR, leader of your organization, but also your management and supervisors. It's part of training. You could start including topics on this, having them understand if they get requests for accommodations due to pregnancy, they need to escalate it. If an employee is not working to the level the manager thinks, and the manager talks to the employee, and the employee says, I'm just so tired, I've been pregnant, it's just really hard. and the manager says, well, we've got a job to do. We need you to meet these goals. We need you on time. This is what I expect going forward. In litigation later, the employee may say, I asked the manager for accommodation. I told him I couldn't do these jobs because of my medical restrictions due to my pregnancy. And his response was, you've got to do better and you've got to do it. I mean, that's not a good case. So I think, getting your managers, people who would be on the front line dealing with these types of situations, understanding, this is another legal flag. I may need to escalate this. I may need to talk to HR. I may need to handle this delicately. This is no different than someone saying they're disabled and they need an accommodation. This falls in that same category, and I'll need to kind of handle this carefully. So with that is the conclusion of the presentation. I'm going to check to see if we've got any questions. All right, great. I do not see any questions. I assume because this presentation was so detailed and thorough, there were absolutely no questions anyone has with the PWFA. I think there's going to be some in the future, though. And because how this law works, it's just not entirely clear for me or the other practitioners in this space. So I encourage you, you've already got the group of laws you're thinking about when employees come to you with issues. This is just a new one to add to that bundle of laws. And, fortunately, they're tools that we understand and use in ADA for dealing with these issues. But if you have any questions or if you need anything else, you can always reach out to us. And I see a few questions popping up. All right, so here's one. If they exhaust FMLA and the Tennessee Maternity Act leave, do you still have to allow more time off? So that's a really good question. So, and it's one point that I want to emphasize. Alabama does not have laws protecting pregnant employees. That's handled at the federal level. Tennessee, for example, and other states do have laws protecting employees on pregnancy. The way FMLA normally works with a disability is once the employee exhausts FMLA, let's say that's 12 weeks, and they ask for an additional time off, that can be a reasonable accommodation under the Americans with Disabilities Act. And so, I would think here the analysis wouldn't be any different. So if someone uses their 12 weeks under the FMLA, and I'm not as familiar with the Tennessee Maternity Act leave, but if they need 4 more weeks under the PWFA, that could be a reasonable accommodation. Where I think, employers could ask a question is, you've been out 12 weeks. Do you need 4 weeks due to your pregnancy? And a doctor may say, yes, this person is having very bad postpartum and they need more time off. And that would probably fall under the ADA maybe. But under the PWFA or the Americans with Disabilities Act, they're probably going to be entitled to more time off. If the employee just needs this time off because they want to bond with the kid, I don't know if that's going to fall under the PWFA. But I think it's going to be real important to think about that. If someone asks for more time off, why? What doctor's notes do we have? How does this interact with the Tennessee Maternity Act leave? How do these all laws work together? Because before the PWFA, you may have just said, no, you had your 12 weeks, you've used up your Tennessee Maternity Act leave, it's time to get back to work. Now we've got the PWFA. And so I think why they're going to need the leave, how long, if someone asked for 30 more weeks, 40 more weeks, that's probably not reasonable. If someone said 2, 3 more weeks, that could be reasonable. Why do you need it? Is it related to your pregnancy? Or do you want to stay at home with your kid because those are different? Those are the things we're going to have to work through. Here's a question for police. If a female candidate tells you she is pregnant and can't work the streets for 9 months, can we pass on her and tell her to reapply after birth? So that's an interesting question. We're always reluctant to give specific answers to questions like that because we'd want to flesh them all out. But it's a fair question. Someone applies, they can't do the job for 9 months. I think the first question is, understanding what their condition, that first month, can you really not walk the street? And it may be the situation, there are situations where you would need to run or engage in a high level of activity. And so a doctor would say, no working the street for 9 months. If that is an essential job function, pre-PWFA, I think you would be in a good position to say, we're not hiring you right now. And the reason would be pregnancy is not a disability. Simply not being able to work the streets for 9 months is not related to a disability. If you're in a state where there isn't any other law protecting this right, if you or anyone else applied for a job and said you couldn't perform the job for 9 months, we wouldn't hire you. I think you'd be in a good spot legally to defend something like that. There are other facts, circumstances, obviously, and that's why I'm just talking in generalities. Under the PWFA, I don't know. It's not clear. To me, 9 months is beyond any sort of reasonable accommodation. I mean, that 9 months is never reasonable, I would argue, but we don't know how far this PWFA goes. We don't know what is reasonable. My instincts would be the PWFA would say 9 months is not reasonable, but we're going to wait for more guidance on that. But I think, that's what I want everyone here, if nothing else, to start thinking about. Whereas in the past, you may have just said, well, that's not going to work. Now, what are our obligations? What do we have to do? How does this law work? And so with each one of these, there's going to be facts and got to work through them all. But again, that's just something we're going to have to start thinking about. And so this next question is similar to that first question. So employee takes leave, 12 weeks FMLA, then another 2 weeks, and then wants to accommodate further and work from home for 3 days per week. Under the PWFA, working from home could be a reasonable accommodation. I think the question, though, is why? Why does this employee want to work from home? Is this, well, I'm having trouble finding a babysitter? I don't think that's what the PWFA is meant to cover. If it is, I'm still struggling with postpartum, this will help me get acclimated back into the workforce. That could be covered under the PWFA. There's a lot of uncertainty about those type situations. I know if that was an Americans with Disabilities Act question and someone needed, extra time off or wanted a 3 day per week accommodation, that's something you'd have the interactive process with them. And you may not have to approve it, but that's what you'd engage in. But part of this PWFA is going to be that interactive process. Why do you need off? How long are you going to need off? Can you do this in the office? Why can't? Is this a position we allow employees to work remotely? Well, if we allow employees to work remotely, then why would we tell this employee they can't work remotely 2 days a week and come in the other 3? Those are all the things you're going to have to work through. And I certainly understand it's going to be complicated. Can we get a copy of the presentation slide? Yes, we can. You can email me directly. You can email Michelle or Christy Berryman, and we'd be happy to send you the slides. But thank you for those questions. Those were good questions. If you notice, I didn't answer any of them directly because this is complicated and we don't know what all the answers are going to be. And it's just going to be a process of working through. The EEOC guidance is going to be really helpful, I think. And I think it's going to talk about those situations. Your 12 weeks of FMLA is over. You want more time off. What do you do? Because I think that is a question in my mind that is going to come up. That's going to come up a lot, I think. And it's complicated. So again, thank you for the time. If you have any questions, think of something after this, feel free to reach out to me, email me, call me. I'm available and here to help. So thank you.